Ladies and gentlemen, if you would take your seats, please. Take your seats, please. Delta Stewardship Council is called back to order. If you would turn to file item number 8. File item number 8. Craig Wilson, the Delta Water Master, is here to give us a report on area of origin. Item number 8. Mr. Wilson. Thank you for coming back again and doing this report. Are you on? No. Red button.
Am I on?
There you are.
All right.
There you are.
Thank you, Chairman Eisenberg, members of the Council. As always, it's a pleasure to appear before you. As you know, one of the statutory responsibilities of the Delta Water Master is to present policy-level reports on various water resources topics to both the State Water Board and the Delta Stewardship Council. And this report that I'm submitting to you today is the 8th in a series of reports since I assumed this job title. And what I'd like to do, basically, as soon as the PowerPoint gets loaded up, is to talk about these area of origin laws. Just by way of introduction, I've heard a lot of people describe these area of origin laws as kind of the sleeping giant of water right laws in California. And the question is, why write this report and why write it now? And I think there's several reasons for that. And I think one is it's just a reminder that these laws are on the books, because I think as water supplies get stretched more and more, and especially as Northern California water demands increase, I think you'll see these laws maybe play a lot more viable role in policy level decisions. There are not a lot of articles been written about the area of origin laws, and most of them that have been written are law review articles written by attorneys. They're fairly complicated, and a lot of them were written in response to a specific case, and they just kind of reviewed a case as it happened. So what I was trying to do is, and as you'll see later in my report, there have been 4 fairly recent cases that have discussed these laws in some length. So what I try to do is just in very layman's terms describe these cases, try to distill some general principles that I think flow from the collective readings of these 4 court cases, and as why these areas are important to California's future is another reason that I wanted to write this report. And as I stated, I think as water supplies are stretched more and more, and as northern demands increase, I think you'll see these laws play a more viable role in the future than they have in the past. So the area of origin laws themselves, as I indicated in the report itself, there are actually 5 laws that constitute the entire concept of area of origin laws. 3 of them are of paramount importance, and those are the ones that I have listed here. I've got the citations to the laws in the report itself. And as far as trying to talk about them, they're written very generally, and I think the dates, as you'll see later in my report, the dates they were enacted, I think are very important to understanding why they were enacted. And basically, they were to provide reassurances to Northern California interests that were concerned when some of the major water projects were being developed. But it was around the time of some of the Owens River controversy. And so it was to alleviate some of these fears of water grabs and to try to reassure Northern California interests. Like I said, the dates of these laws are important to understanding why they were enacted. And they really were enacted either closely following or contemporaneously with some of the major developments of north-south water supplies. The first one, the County of Origin Law, was passed in response to an earlier enactment which kind of reserved certain water rights to the water projects that were being developed. The second one, the Watershed Protection Statute, was part of the Central Valley Project Act, which was originally a state act, and it was eventually taken over by the federal government because of the state's inability to finance it because of the Depression. And then the last act, the Delta Protection Act, was tied to the passage of the state water project legislation. So these dates are very important. And what I tried to do in this slide is just try to kind of develop kind of the common theme as I saw it from reading all of these statutes. And so they were basically enacted to ensure that the areas where the water originates shall have an adequate water supply for present and future needs. But the laws were not intended to preclude the export of water to other areas before those needs arise. Instead, the needs of the area of origin take priority if and when they do arise. Now, turning to some of the court cases, like I say, there were not a lot of case law on the area of origin laws until fairly recently. So that's why I list some of the Attorney General's opinion. There were a couple of them written in the mid-1950s that did attempt to articulate the general purpose of the laws. That they're somewhat dated, but I think they still have important information, and they, I think, in some respects, have been superseded by a lot of the case law that's come into place since 2006. There were a couple of earlier court cases that I didn't include and maybe should have. There was one court case called Fresno versus California. It was adopted in 1963. It kind of dealt with the area of what was an adjacent area to a watershed, what area was really covered by the watershed protection. And it seemed to be fairly narrow in scope, although some of you might remember about 10 years ago there was an attempt by a water agency in the west side of the valley to claim area of origin protection to like a third of the flows of the San Joaquin River. It set off all kinds of whistles and bells and alarms, and it kind of quietly subsided away. The other case I could have mentioned is just the classic case of California versus U.S., which established the principle that state water right laws applies to federal projects, and that certainly included the area of origin laws. So the remaining slides, I just attempted to go through these four court cases that have been adopted since 2006 and try to distill some general principles from them. I think a lot of them are self-apparent and not controversial. A couple of them people might disagree in part, and I'll call those out when I get to them. So there's these conclusions, right? I think the intent of the law is pretty clear in general, but because the laws were written so generally, that's why these court cases become very important. Like I said, these four recent court cases, I think one thing that's important to realize about these court cases is who authored these court cases. The four cases I mentioned in my report, two of them were authored by Justice Ronald Roby, who has a very extensive water background, and I would consider him to be the preeminent water jurist of our time. One of them was a review at the federal level, a very recent case, which was reviewing a district court decision written by Judge Wanger, another prominent water jurist. And then the last state opinion was written at the Third District Court of Appeals by if I get the pronunciation right, Chief Justice Sakatui, because she was on the Third District Court of Appeals at the time, but now, as you know, is the Supreme Court Chief Justice. And I think these court cases are kind of interesting because all four of them actually considered and rejected area of origin claims. And I think in most of these cases, people were really trying to reach and stretch the outer boundaries of the cases. In one of the cases, people were trying to use the area of origin law to get a preference over other uses within the area of origin itself. Another one was trying to establish the fact that the area of origin laws themselves independently created a water right. Another one was talking about giving preferential treatment to stored waters. So even though the claims were denied in these cases, and there were other claims and courts of action in those cases that were probably more important, in discussing the area of origin laws, I think all of the cases were painting with a pretty broad brush and saying that these laws did have a lot of weight behind them. As an example, another example, the Tehama case, the federal case, it's the most recent case just decided a few months ago. The plaintiffs were in essence trying to get a priority that their own water service contract directly contradicted it. So to me, it was more of a contract interpretation case than a area of origin case. But the court did go out of its way to review all of the more recent area of origin cases and did make some pretty broad statements. A lot of would be considered dicta in the eyes of the attorneys, more persuasive authority than precedential authority. But a common theme of these cases is that the laws unquestionably apply to both the federal and state projects, and they also make it clear that the laws do not independently create a water right for area of origin inhabitants, rather a water right must exist before the protections of the laws may be invoked. Having said that, it's clear that even if there's no water right in existence, the area of origin laws provide a means for an area of origin inhabitant to acquire a water right that would have priority over the water rights of the export projects. In essence, if someone within an area of origin filed an application with the water board for an appropriate water right, that the priority would first in time, first in right would be sort of flipped for area of origin people, and they would go certainly to the head of the line ahead of the project's priority. Now, there's some interesting caveats regarding stored water. As you know, the federal and state projects spend a lot of money to develop water and store that water. And basic water rights law is pretty clear that the projects have priority to that stored water as opposed to natural flow. So even where area of origin laws apply, those laws do not apply to stored water. But the laws do make it clear, and at least in my view, and this is the slide that might raise some controversy, and you might hear some speakers speaking about it. In my view, area of origin inhabitants have the right to purchase stored water from the projects, both the federal and the state. I think state is very clear. At the federal level, there might be some opinions to the contrary because of one of the laws that applied the federal government to the area of origin laws didn't apply all of the law, only certain sections. But I think reading the law in its entirety and looking at the purpose of the area of origin laws, my view is that area of origin laws, inhabitants have a right to purchase stored water from the federal government as well as the state. That was certainly Justice Roby's opinion in the El Dorado irrigation case. But the other caveat to this case is that, and this is basically flows from the Tehama case, the federal case, that unless the contracts have some sort of special status, that when people purchase water, from the government, they have to, take their they don't get a special priority to that water. They are subject to the same curtailment terms as others. That's what the Tehama case was all about. The Tehama people actually signed water delivery contracts that had curtailment provisions in there, and then after the fact tried to go to court to say that they should have some priority. I think it was a pretty easy call for the courts. I think the more interesting case would have been if the area of origin people had attempted to purchase water from the federal government, and federal government had resisted without putting curtailment provisions in there, and if the parties had gone to court and say, even though that term isn't in there, we feel it should be. I think some of the language in the Tehama case is probably dicta on the point of whether or not there's priority. So there's some room for disagreement on that point. And my very last slide, I wanted to at least bring this home to the Delta and how the area of origin laws really work in the Delta. Because the Delta as an estuary will always have some natural flow in that, and the area of origin laws certainly provide protection as to valid water right holders as to natural flow. The question becomes whether there's really enough natural flow in the Delta to satisfy all water right holders. And of course, even where water rights exist, they're subject to the mandates regarding efficient use and public trust. So with that, I'll close and leave it open to questions. With just the couple of main points that I think the laws are old. There hasn't been a lot of case law on them, but I think they remain very relevant. I think some of the recent court cases have defined the outer boundaries of the laws. And I think in the future, I think they could have a lot of relevance. Just an example with some of the climate change and the differences in flow regime. You might see cases where people north of the Delta in area of origin might attempt to apply to the water board for permits to take water at different flow levels when maybe in connection with conjunctive use projects, whatever, and that might be a viable use of area of origin. There's also instances where the area of origin laws could be used as leverage with the projects in negotiating some of the water service contracts. I think you heard this morning from a law student that they had come and talked about a recent settlement with the Department of Water Resources, and I believe it was Solano County or the city of Fairfield, where those entities had actually applied for water rights from the board, but that it was still negotiating with the projects for contract water, and I think they ended up canceling those water rights because they were able to get terms that they were satisfied with, so they were able to use the area of origin laws to some extent as leverage to get contract provisions that were more favorable than they might have been. So with that, I'll close unless there are any questions.
Okay. Yes, Mr. Fiorini, and then Judge Damrow.
Craig, is an interesting report. Thank you. Is there any connection to area of origin rights, diverted and stored water, as it relates to dry year operations and the amount of water available for use in the Delta? Is there any connection, or?
Yeah, I think the connection. I think what the the Delta Protection Act basically says is that people in the Delta have to the extent that they have water rights are entitled to an adequate water supply. But I think some of the court cases said what that supply is up to some of the regulatory agencies, such as the State Water Board. So that goes back to the one slide that I stated that when you're talking about natural flow, there's always some natural flow in the Delta because it's an estuary. But whether it's not enough to satisfy all those water right holders is kind of the question of the day.
Question regarding this last paragraph. Whether there is enough natural flow in the Delta to satisfy all valid water rights holders may be an open question. How do you determine natural flow or sufficiency of natural flow, and how do you determine who are the valid water rights holders?
Yeah, as far as determining valid water right holders, that's one of the things I spent a lot of time trying to go through in the Delta. I think there's close to 3,000 entities in the Delta that are diverting water, and about 2,700 of those, 90% or so, are claiming water rights under either riparian right because they own land contiguous to the water course, or they have what are called pre-1914 water rights. They're not subject to a permit or license from the Water Board. So those water rights are less well established, although and what my office has been doing is trying to go through the validity of those water right claims, and at least to date, the vast majority of the claims at least have been satisfied to our satisfaction in my office. So as far as the natural flow question, it's a lot easier to answer in the upstream water courses, because at any one time there's, like the Sacramento River or some of its tributaries, it's commingled water, natural flow versus stored water, and the projects keep pretty good track of how much water they're releasing, and you can look at statistics on their web pages, and you can see how much water is stored water that's being released versus natural flow. The Delta gets a lot more murky, no pun intended, because of the fact that it's an estuary. I think people in the Delta will say, hey, there's always sufficient natural flow in the Delta because of the tides going back and forth, and just because the projects are releasing stored water in there shouldn't have any impact on that, because the water would be there anyway. Maybe it would be a little saltier, maybe it wouldn't. Conversely, people in the projects and the export contractors would say, that stored water can be accounted for and should be, should not be subject to use by Delta people unless they pay for it. But it gets a little bit difficult to quantify exactly what's natural flow versus stored water releases in the Delta itself.
Thank you.
I'm sorry, Ms. Gray.
First, thank you, Mr. Wilson. It's always good to see you, so thank you for your report. I kind of want to pick up on some of the things that's been discussed. I think you've kind of alluded to some way that this information can be applied to the Delta plan, or some of the questions, and that's kind of my general questions. We've adopted the Delta plan. We're in the implementation process, and there's some other things that are going on. How does this information fit directly into what we are doing moving forward?
Maybe I'll start with the 2009 legislation itself. There were a couple of references to the area of origin laws. I think one was just kind of the general disclaimer that nothing in the legislation is impacting on the laws themselves. But there was also a provision that stated that to the extent that conveyance facilities are used to transport water to the south, people to the south of the delta could not use the argument that they are somehow tributary to the delta and would be able to get area of origin protection. I think the relevance maybe to the delta plan is that obviously to the extent that the water rights are valid in the delta and people are making use of water, a fairly significant use of water, that impacts how much water is flowing out of the delta to meet water quality standards, how much water is available for export to the south. So I think it has some relevance both to the reliability, co-equal goal, the reliability of the water supply, and what we're trying to do is by providing more certainty as to how many people are actually diverting water in the delta, how much water is being diverted, and the validity of those water rights. And I think you'll have more certainty as to the impact of delta diversions on some of these more overall policy issues, such as the reliability of water supply. It also impacts, I think, on your other co-equal goal about water quality and protection of the ecosystem, because to the extent that people are validly diverting water from the delta, much of that's being returned to the delta because of the way that the estuary works. But there could be some issues about whether use is efficient and reasonable by even valid water right holders, and there could be some claims made that irrigation practices should be improved, things should be done to make sure that people are using water efficiently so that water quality protection and outflow standards are being met.
Thank you.
Mr. Wilson, a couple of things. What's the interconnection, in your judgment, between area of origin laws, particularly as they exist today and might in the future, and the duty of the State Water Board to review rivers, streams in California and determine those that are oversubscribed, meaning the capacity of the river or stream is fully used? How does the area of origin fit in that situation? Because it seems to me it's likely that there will be an increasing number of rivers and streams and tributaries who get that designation at some point.
Yeah, that's a very good question, because it raises the paper water rights issue, that there may be paper water rights for much more water use or potential use than there is even in the water courses themselves. My reading of the area of origin laws is that it might bring to some extent some uncertainty regarding those issues. I believe even if the water board has a declaration that a water course is fully appropriated, that if someone thereafter filed for a water right on that water course and claimed area of origin status, that the board would have to, I think, consider that and possibly revisit the area, the issue of whether that water course was oversubscribed, and potentially potentially approve that water right and knock somebody down the list farther. I know it doesn't make things as certain, but I think that's what the law, the way it was envisioned, that if future needs arise, that those needs would at least take priority over the project's permits and licenses.
The other thing that struck me about the area of origin's role in current water debates is lawyers are pretty careful when they're in public talking about it. Not always, but pretty careful in my opinion. But most real people are not necessarily that careful. And I noted, was it the mayor of Oroville about 30 days ago got quoted at a water commission hearing saying something like, well, God gave me the water in Oroville and you're getting it from me. And that seems, of course, to assert a different level of activity. But the thing that's puzzled me in the dispute is what I think is a growing concern, which is not just paper water, but it's the realization that the opportunity to make a lot of money if you can glom on to paper water rights, somehow seems separated from the fact that the Constitution requires that water be beneficially used and be reasonably used, and there can be no wasting. And I just have never been able to connect the lines between all of those themes and make it coherent. But you probably could.
I'm not sure about that. I think maybe the issue that comes to mind after hearing those comments is some of the transfer provisions in water in the water code, and as people have valid water rights and are maybe trying to transfer water into those water rights to a greater need of use, that the water board looks pretty carefully at those and makes sure that of a couple of things, that the water right itself is valid, that no other lawful user of water is damaged by a transfer, and that the in-stream uses of the water course being used to convey the water would not be injured as well. So I think there are some limitations on the ability of people to just transfer water without having some scrutiny over whether it's causing some harm to the overall system.
Isn't a more rational water policy largely dependent on factual accumulations of how many water rights and permits there are, legal uses and illegal uses, and so on? And the Water Board has struggled with that for years, and all the reports are pretty clear that the pre-1914 claims are not as well documented, of course, as the ones that have gone through the Water Board, and there could be some illegal uses out there that nobody knows about. But the reality is we have a total volume of water rights, particularly in the Delta watershed, that far exceed the average flow in the Delta. Part of that is attributable to use and reuse of water downstream of the first use. You presented, I believe, an early paper in 2011 that was addressing possible changes and recommendations on reporting data and information. And I don't know, is there anything in the works at the Water Board responding to that?
I think what you're referring to is I had a report on the water right enforcement statutes, which included some of the reporting provisions, right. and the basic conclusion of that report is that you had a very robust enforcement and reporting program on the water quality side of the state board's business, not nearly as robust on the water rights side, and I made some specific recommendations. I believe there were some attempts even last year in the legislature to address that, but and it might have gotten. I don't know the legislative process nearly as well as you, for instance, but I believe there was some attempt even made through the budget or trailer bills. But the problem is, I think the people maybe overreached. They tried to put more provisions in than the core of kind of recommendations I had made, and it didn't go anywhere. Whether the board is recommending to the governor's office changes in some of those reporting and requirements, I have not been involved in that. I do not know.
Any other questions? Mr. Wilson, thank you very much. You're now going to do one report every 3 weeks. Is that what you promised to do?
No, sir.
I would urge you to keep it up. These are very valuable, Craig, and I think quite helpful.
Thank you.
Quite helpful.
Thank you.
Okay, good.